Next, from the Illinois State Senate, we hear a debate on a constitutional amendment that would provide a series of protections for those who are victims of crimes or family members of victims. This runs about 25 minutes.
Throughout the criminal justice process. 2. The right to refuse to disclose to the defendant information that is privileged or confidential by law as determined by a court of law with jurisdiction over the case. 3. The right to timely notification of all court proceedings.
Let's cut down some of our conversations so we can hear. Thank you.
4. The right to confer with the prosecution. 5. The right to be heard at any post-arraignment court proceeding in which a right of the victim is at issue in any court proceeding involving a post-arraignment release decision, plea, or sentencing. 6. The right to have access to information in a report related to any aspect of a defendant's sentence when available to the defendant as the General Assembly may provide by law. 7. The right to be notified of the conviction, the sentence, the imprisonment, and the release of the accused. 8. The right to timely disposition of the case following the arrest of the accused. 9. The right to be reasonably protected from the accused throughout the criminal justice process. 10. The right to have the safety of the victim and the victim's family considered in denying or fixing the amount of bail, determining whether to release the defendant, and setting conditions of release after arrest and conviction. 11. The right to be present at the trial and all other court proceedings on the same basis as the accused, unless the victim is to testify and the court determines that the victim's testimony would be materially affected if the victim hears other testimony at the trial. 12. The right to have present at all court proceedings, subject to the rules of evidence, an advocate and other support person of the victim's choice. 13. The right to restitution. B. A victim, the victim's lawyer, or the prosecuting attorney may assert the rights enumerated in subsection A in any court with jurisdiction over the case as a matter of right. The court shall act promptly on the request. C. The General Assembly may provide for an assessment against convicted defendants to pay for crime victims' rights. D. Nothing in this section or any law enacted under this section creates a cause of action in equity or at law for compensation, attorney's fees, or damages against the state, a political subdivision of the state, an officer, employee, or agent of the state, or of any political subdivision of the state, or an officer or employee of the court. E. Nothing in this section or any law enacted under this section shall be construed as creating 1. A basis for vacating a conviction, or 2. A ground for any relief requested by the defendant. Schedule. This constitutional amendment takes effect upon being declared adopted in accordance with Section 7 of the Illinois Constitutional Amendment Act. Third reading in full, as amended, of this House Joint Resolution Constitutional Amendment.
Senator Staines to explain.
Thank you, Mr. President, members of the Senate. We are now talking about putting a constitutional amendment on the ballot in November. This is HJRC A29, otherwise known as Marcy's Law, is in response to years of work and effort. Illinois first passed a crimes victim rights law in 1985. In November of 1992, the people of Illinois overwhelmingly adopted Article 1, Section 8.1 of the Illinois Constitution. This section gave crime victims various rights, including the right to be treated with fairness and respect, the right to notification of court proceedings, the right to attend proceedings on the same basis of the accused, unless the court made a specific finding, and the right to make a victim impact statement. Unfortunately, the victim's rights are frequently violated. Attorney General Lisa Madigan held 5 roundtables across the state in the spring of 2008 to hear from victims and advocates about the experiences with the criminal justice system. We're here today because of what we learned in those roundtables. Victims testified that they were not advised of their rights, that they were not provided timely notice in all cases of court proceedings, that there were no communications with the prosecutor until a plea agreement had been reached, that they were excluded from trials, and that they were not afforded the opportunity to present a victim impact statement. We have a number of victims with us in the gallery today who you may have been hearing from. I just want to acknowledge them. We have Garrett Evans, who is a Chicago native who survived the Virginia Tech massacre. We have Mary Kay Mace, who is the daughter Ryan was killed at the NIU massacre. Marilyn Wagner, whose brother Larry was murdered here in Springfield in 2010. We have Jennifer Bishop Jenkins, whose sister, brother-in-law, and their unborn child were murdered in Winnetka, Illinois. We have Lisa Bobb, who's a mother of a murdered victim. There's been many more that you've probably been hearing from. To this day, we hear from victims that their rights have been violated. Now, the problem and the reason that their rights get violated is because there's no enforcement mechanism. Victims in Illinois then feel that they get re-victimized when they're told they don't have, that their constitutional rights that we had already passed in the Constitution, that they cannot assert their rights and there's no remedy or recourse available when their rights are violated. That's why we're here today. Victims in other states have an enforceable right, and Congress provided for enforceable rights in federal cases in 2004. Victims in Illinois should also have these enforceable rights. This constitutional amendment that's before us today gives victims the ability to enforce their rights in two ways. First, by giving them standing in the courtroom to assert their rights. The second method is to revoke the existing constitutional language that bars appellate relief. This language is not found in other state constitutions governing victims' rights. It is also inconsistent with the United States Supreme Court recognition in 1803 in the landmark case of Marbury versus Madison that where there is a legal right, there should be a legal remedy. HJRCA 29 removes this bar to appellate relief for victims, but retains the language that prevents the defendant from using a violation of a victim's right to vacate of conviction. States with similar language in their constitutions have amended their constitutions to provide for the enforcement and vindication of crime victims' right. We're the only state that has not removed this constitutional prohibition. Most importantly, experience shows that the defendant's rights are not diminished when the victim's rights are respected. Courts are fully capable and routinely balance constitutional rights, giving full effect to each. Procedures are established to ensure the continued efficiency of the trial in appellate courts. Now, I also want to assure folks, we'd heard testimony and concern from the state's attorney's office. The state's attorney's office is having much input. We've been spending a great deal of time working with them on the enabling statutes that will go along and that we will also be working on passing to implement this constitutional amendment. And these legislation, the enabling legislation, will clarify that the victim's attorneys in this only have standings on issues regarding the victim's rights. I want to thank, a constitutional amendment is a very significant issue. I want to thank very much my colleagues, Senators Hayne, Senator Harmon, and Senate President Cullerton, who have spent a great deal of time working with all the parties on this issue of an interest in making this a place that I feel very confident will be done in a way that respects everybody's rights. I will look very much forward to passing this bill with your input today, and happy to answer any questions.
Senator Hayne. Is there any discussion? Senator Hayne.
Thank you, Mr. President. Would the sponsor yield for a question?
Sponsor indicates she will yield, Senator Hayne.
My question is this, Senator Staines. Can a victim veto or in any way obstruct a plea agreement reached between a prosecutor and the defense attorney?
Senator Staines.
No. Only the prosecutor and the defense attorney can agree to the terms of a plea agreement. The victim has the right to confer with the prosecutor prior to the entry of a plea agreement, as well as the right to notice and an opportunity to be heard when the court enters the plea agreement. While the victim has the right to state his or her sentiments about the offered plea agreement, the victim has no authority to alter or veto this agreement.
Senator Hayne.
To the bill, Mr. President, and ladies and gentlemen of the Senate, I am very appreciative of all who worked on this important amendment, and just offer some thoughts about it. As a former state's attorney in Madison County, the concerns of the bill from the state's attorneys that I have spoken with never had to do with the premise that a victim is given a special status in our court system. Never was any opposition given to the idea that victims should have notice, should be spoken with, should be cared for. The state's attorneys that I've spoken with over the years, including my own office, established protocols to deal with victims and their unique issues. The concerns that have been expressed had to do with the constitutional premise that the state's attorney only speaks for the people of Illinois. And the state's attorney's primary duty is the faithful enforcement and execution of the laws of Illinois, especially the laws that prohibit violence against other citizens. The state's attorney can never be removed from that position except according to law in limited cases. The Supreme Court of Illinois has ruled that the state's attorney is the chief law enforcement officer of the county, the chief, and in that role has the duty to protect citizens, victims, and citizens at large through the faithful execution of the law. That means the state's attorney's duty must see that justice is done, that it isn't a narrow interest of a plaintiff. It is the broader interests of justice. There could be situations where victims may be reluctant to pursue the full measure of law. The state's attorney is the one who determines that it is. And these issues are very important to maintain because the state's attorney is accountable to the people of Illinois. That officer and those who serve under him or her are all accountable. They're employees at will. And they're employees at will because they have all the power of the state's attorney. And what the concerns were that this would diminish this authority. We all want and desire that victims be treated with care and compassion. And the people that represented them did so ably in the formation of this amendment, and they do so ably around the courthouses of this great state. But it must be kept in mind that the most compassionate thing to be done for a victim and the most care to be done for the community at large is to have evildoers punished. That is the primary therapy. No one who suffers a rape or murder of a loved one is going to be made whole by notice. They are never going to be made whole. When that terrible act occurs, it occurs against the victim, but as our informations and indictments say, that act violates the peace and dignity of the people of Illinois. And the people of Illinois wish to exact just punishment. And the officers that are commissioned by the Constitution and elected by the people go into the well of the court in this state every day to tell the truth and nothing but the truth to a jury or a judge and to exact punishment. That is what the primary right of a victim is, to have that state's attorney bring evildoers to the bar of justice and punish them. But we support this bill. We have moved as a society toward this. The state's attorneys that I know and have talked to support this, and I'm grateful for the care with which this sponsor has maneuvered this bill through this deliberative body. I would recommend that I vote. Thank you.
Senator Crotty, for what purpose you seek recognition?
To the bill.
To the bill.
Victims and their families need a voice. People who have been battered, raped, and abused, or lost loved ones to murderers are part of every community. Too many times they're denied the rights that they deserve while seeking justice for their incredible loss. Like Jamie from Perry County, Illinois, a victim of domestic violence whose estranged husband, a repeat offender, was released on a plea deal without any notice to Jamie, who is still in grave danger. Like Pamela and Tommy from Chicago, whose only son was killed as an innocent passerby in a gang crossfire. These devastated parents endured 2 years of court proceedings during which they were held in a small room with an unapologetic, unsympathetic, and unruly family of the defendant. Their requests to be moved to a new space were declined. These parents report that the trauma of having to endure such horrific close quarters has been worse than any other aspect of their lives following their son's murder. Then there's Glenn, whose girlfriend was repeatedly violent. Law enforcement and others didn't take Glenn seriously because he was a man. When Glenn's girlfriend stabbed him, prosecutors didn't charge her with attempted murder, despite her admittance to the crime. After more than 2 years of continuances, trial proceedings finally began, and witnesses traveled from far and wide to testify on Glenn's behalf, only to be turned away when the trial was given another 4-month continuance based on the defendant's schedule only. And just in the last 2 weeks, when we passed Julie's law, when Julie's parents wanted to give an impact statement and were told that they could not give that impact statement until I inquired for them and told Rich and Pam that they do have that right. These are real stories of fellow Illinoisans, and these just brush the surface of folks in our state who are suffering. And that's why I urge you to vote aye for Marcy's Law, an amendment that will make a difference in every day in the lives of individuals and families who are suffering enough.
Senator Harmon.
Thank you, Mr. President. Will the sponsor yield?
Sponsor, in case you will yield, Senator Harmon.
Thank you, Mr. President, ladies and gentlemen of the Senate. Senator Staines, when this amendment came over from the House, it was quite a bit longer, a bit more unwieldy, and frankly dealt in a level of detail not typical of a constitutional provision. I applaud you for your work in narrowing this down and turning it into what I think is truly a constitutional amendment. I also would thank Senator Hayne, our in-house state's attorney, and President Cullerton, our public defender in residence, for their expertise in making sure that this is a fair and balanced constitutional amendment. I also applaud the advocates who have worked so hard on this, and the state's attorney and the bar associations who have brought a leveling voice. Part of the problem in tailoring the constitutional amendment is we do lose some detail, and it has become obvious that we will be enacting enabling legislation that will deal with many of the concerns raised by the state's attorneys and by the bar association. But I think in particular, in light of that, both the Senate and the record would benefit from a slightly more expansive explanation of the legislative intent that we have developed in this. Would you be willing to share that with the Senate?
Senator Staines.
Yes, thank you, Senator Harmon. And again, I want to reiterate, he's thanking me, but it was really Senator Harmon, Senator Hayne, and President Cullerton who brought all the parties together to really make this workable. Many hours of work on something that he was not even carrying himself, so many, many thanks. And the legislative intent I would like to put on the floor for HJRCA 29 it follows here. Subsection B of the proposed amendment expressly confers standing on the victim to assert the rights afforded to the victim in subsection A. Subsection B further provides that the victim, the victim's lawyer, or the prosecuting attorney may assert the victim's rights on the victim's behalf. The reference to the victim's lawyer in this amendment is to a lawyer retained by the victim for the purposes of asserting the victim's constitutional rights. A lawyer retained by the victim means a lawyer who is hired to represent the victim at the victim's own expense, or a lawyer who has agreed to provide pro bono representation. If the victim has grounds to allege legal malpractice, the victim may seek redress in the form of a civil malpractice action against the lawyer. Section D provides that the victim is not entitled to any cause of action against the prosecutor. HJRCA 29 does not confer upon the victim the right to a court-appointed lawyer or a lawyer at public expense. Had the General Assembly wanted to afford a victim the right to a court-appointed counsel or counsel at the public's expense, it would have included the right to counsel in the list of rights enumerated in subsection A. We should note that since January 1st, 1994, Illinois statutes have expressly provided that a crime victim has the right to be represented by a lawyer at the victim's own expense, and that state's attorneys are obligated to tell victims that they have this right. The scope of the representation of a victim is specifically delineated in subsection B. A victim, the victim's lawyer, or the prosecuting attorney may assert the rights enumerated in subsection A in any court with jurisdiction over the case as a matter of right. This means that the lawyer asserting the victim's rights, whether that is a privately retained lawyer or the prosecutor, may invoke the Constitution, laws, and court rules of this state in any trial or appellate court in which a victim's right is at issue. The lawyer's representation of the victim does not extend beyond asserting the specifically enumerated rights. To assert the victim's rights, the victim, the victim's lawyer, or the prosecuting attorney may file a motion or orally assert a right at a court proceeding. Experience in other states and the federal courts tell us that this vast majority of those motions will be filed and ruled on prior to trial, thus avoiding any delay in the trial process. With this provision, the General Assembly should ensure in the enabling statute that if a victim's rights issue arises during trial, it should be disposed of outside the presence of a jury. Practically speaking, a lawyer's representation of a victim under this amendment does not involve or contemplate making the victim the equivalent of a named party in the case. Specifically, the victim's lawyer would not have the right to 1. Dictate or control the prosecutor's discretionary decisions, 2. Direct the prosecutor to file specific charges, 3. Veto a plea agreement, 4. Present or object to evidence at trial, 5. Call, question, or cross-examine witnesses at trial, or 6. Impose a particular trial strategy on the prosecutor or defendant. Finally, the only real non-distinction between a victim's lawyer and the other lawyers of record in a criminal case is that each of the lawyers would receive copies of all notices, motions, and court orders filed in the case. In Section A, Paragraph 4, the victim's right to communicate with the prosecution has been changed to the right to confer with the prosecution. The right to confer is broader than the right to communicate. Confer means more than the transmission of information. It means to consult together, compare opinions, and carry on a discussion or deliberation. A prosecutor conferring with the victim or the victim's lawyer, however, does not mean that the victim or the victim's lawyer would have the ability to dictate prosecutorial decisions or trial strategy, as these rest in the sole province of the prosecuting attorney. In Section A, Paragraph 6, the victim is given the right to access information in a report, but not necessarily a copy of the entire report prepared prior to a defendant's sentence. This right is limited, as the General Assembly may provide by law. In the companion enabling legislation, the General Assembly is to ensure that the victim does not have access to confidential medical and mental health information about the defendant's sex offender evaluation, information that would identify other victims, privileged, confidential, or irrelevant information about persons other than the defendant, or information that compromises anyone's safety or invades a person's reasonable expectation of privacy.
Any further discussion? Senator Raoul.
First, I'd like to commend the sponsor and Senator Harmon and Senator Hayne for their work on this. I think most of the members of this chamber know the role that I play on the Criminal Law Committee. There's one concern that I do have with this, and the analysis refers to the right to refuse to disclose information based on it being characterized as privileged or confidential. I can understand the desire to protect information that is genuinely privileged or confidential that has no relevance to the matter being prosecuted. But the terms privilege and confidential can be, we're putting this in our state constitution, right? And so they can be broadly applied to some relevant evidence that could be exculpatory evidence. Is there something by way of legislative intent or the trailer legislation that will deal with such evidence?
Senator Staines.
Yes, part of the legislative intent I just read directly spoke to that, and we are working with all parties on the enabling legislation to provide clarity. And that's part of the reason why we did enabling legislation, and reduce how much was going into the constitutional amendment. So as there are issues, you can come back and change the statutes that are implementing this part of the Constitution.
Senator Raoul.
So, so it is not the intent to prohibit a judge presiding over a case from deeming information that would otherwise seem as privileged or confidential admissible or subject to subpoena or disclosure and discovery.
Senator Staines.
Yeah, excellent question. No, one thing, I'm going to read the full paragraph here too, because it's very clear that it's totally under judicial discretion. The right to refuse to disclose to the defendant information that is privileged or confidential by law as determined by a court of law with jurisdiction over the case. Very much want to maintain that discretion as it belongs with the judge in the case.
Senator Staines to close.
I really want to just close by saying that what this constitutional amendment does is ensure that folks who have been victims of molestation, of rape, whose family members have been murdered, will now be confident that their rights can in fact be enforced, that their right to have a voice and to be informed of what's happening in trial proceedings are enforceable at this point. I really want to just acknowledge and thank the victims, their advocates, Lynn Shillette and others from ICASA, and Cindy Hora and others from the Attorney General's office, Jennifer Jenkins Bishops, who have been spending so much time over a number of years bringing us to this point. And then the many folks in this chamber who really have made sure that we are being fair, we're being balanced in the way we're approaching this. I look forward to getting this on the ballot and letting the people of Illinois have the final say in being able to provide the rights to our victims, and now making sure that those rights actually can get enforced. Thank you very much, and I would appreciate your support on and an aye vote on this constitutional amendment.
The question is, shall House Joint Resolution Constitutional Amendment 29 pass? All those in favor will vote aye. Opposed will vote nay. The voting is open. Have all voted who wish? Have all voted who wish? Have all voted who wish? Take the record. On that question, there are 55 voting yea, 1 voting nay, 1 voting present. House Joint Resolution Constitution Amendment 29, having received the required constitutional majority, having received the required 3/5 constitutional majority, is adopted and declared ratified.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.